Every day in the USA, people find themselves in court.
Good afternoon.
Hey, how you doing, Mr. Black? It'll be just a minute. I'm trying to get your attorney connected and waiting on the judge, okay?
Yes, sir. Thank you.
Okay, here we go. Good morning. Good afternoon.
Good afternoon. Yeah, I'm just waiting on the judge to take the bench.
Very good. Thank you, sir. Mr. Black, do you have any priors?
I'm on probation for trespassing, sir.
Currently?
I'm scheduled to end this month. Yes.
Yeah, are you on probation at Oak Park?
Yes.
Okay. Who's your judge?
Was I honestly don't recall. I want to say I don't remember the name. I want to say the first name Lindsay.
No.
No, I don't. I honestly don't remember. I honestly don't recall. I've only been dealing with my probation officer.
Judge Horowitz.
Oh, Judge Horowitz.
Okay.
Okay.
That's who you have today.
Great. Anthony, you understand what you're being charged with?
I believe so, but I would like to be confirmed.
Okay. You're being charged with the making a bomb threat, false threat of bomb or harm. It's a 4-year offense. Okay. So what we're going to do is we will waive the formal reading and stand mute. The court will enter a not guilty plea on your behalf. I will make a recommendation for bond. We'll talk about bond. Your father is there. So it's family support. You live in the neighborhood. Things that we've talked about before.
Yes, sir. Thank you.
Anthony, it's false report or threat of terrorism.
Understood.
All right, this is case number 240065SL. This is the People versus Anthony Joseph Black. All right, we're here today for an arraignment. All right, Mr. Talenda, give me your appearance, please.
Good morning. Good afternoon, Your Honor. For the record, my name is Paul Talenda. I'm here on behalf of Mr. Anthony Black. I was just recently retained in this matter. This is a walk-in on a warrant that we were notified of. I want to say, Your Honor, it was about somewhere around noon that the family was notified of the warrant. We did make arrangements to have Mr. Black come here as soon as possible.
Okay. All right, and as to the formal reading?
Your Honor, my client understands what he's charged with. We'll waive the formal reading, stand mute, ask the court to enter a plea of not guilty on his behalf.
All right, we'll enter a plea of not guilty on behalf of your client. You are retained. Is that correct, Mr. Talenda?
That's correct, Your Honor. Thank you.
All right, and we'll have I don't have a probable cause conference date. Give me just one moment.
Thank you.
Sorry, Ms. Pullen, this happened kind of quick. Give me just a second.
No problem.
All right, we're back on the record. So, Mr. Talenda, just a question. This case is my case. However, I'm going to be out of the country next during the time frame that the PCC needs to happen. So, I guess the question is it okay with your client to have his PCC in front of Judge Apple, or do you want to waive the time period and schedule it a little later?
Please correct me if I'm missing something here, Your Honor. I don't know if it makes a difference to my client. Does it make a difference to the time frame? I mean, we can waive the formal reading. I believe that my client has a trespass case in front of this court as well.
Yeah. I guess the only issue is, if he's still in custody, he'll probably want it sooner rather than later. But we haven't gotten to that yet. So I think we're just going to schedule this in front of Judge Apple. That way he has, all right. We're going to get a Judge Apple date for you. And then if you set the exam or during the PCC, it'll come back to me.
Okay, great. Thank you so much.
Okay. Just give me one moment.
Thank you. Can I ask where the court's going? Someplace fun?
Ecuador in the Galapagos. Yeah.
Wow. My trip to Florida doesn't seem so cool anymore.
Yeah, I'm just chaperoning a school trip, so there's not going to be any hot water
I was gonna say that's not a vacation.
26.
All right, I apologize. We're back on the record, 24SL0065. All right, our probable cause conference is going to be March 26th at 11:10 a.m. That's March 26th at 11:10 a.m. All right, Mr. Tolenda, let's talk about bond.
Your Honor, my client's aware of the serious nature of this. I believe that this matter was communicated between him and a paramour, or perhaps a potential romantic relationship. Your Honor, I believe that after this event was reported, my client has spent the last couple weeks in a place called Stonecrest, which is a mental health facility. My understanding is that he was there addressing some of the issues which brought him to court. What I would ask the court to do is, considering that I believe his father is there in support, his father has been his primary support. He is a homeowner in Oak Park. As a matter of fact, I believe they're both homeowners at Oak Park, so they do have community ties. I'd ask the court, considering that he does have an existing misdemeanor case, I'd ask the court to set a personal bond or a low bond, as I don't believe that he can flight risk. If the court's concerned about security in terms of community danger, we can create some parameters as to who we may contact using his communications device. I'd ask the court to consider those for bond condition. I'd be willing to discuss more if the court would like.
I don't have the benefit of a bond report in this case. However, Detective Mata from Oak Park Public Safety is here, and I believe he wanted to address the court regarding bond. Detective Mata, would you please state your name for the record?
Detective Mata, M-O-T-T-A. Your Honor, in the OIC on this case, and a couple of things I'd like to point out as referring to bond. Of course, the nature of the threats that were made are very serious, threats to not only to harm himself, but others, including threats towards the school. I've spoken to many people while investigating this case, including some family members who have expressed their opinions on being worried about Mr. Black, but also being afraid of what he might do. He apparently has trouble keeping his temper, but also remaining sober. The access to drinking and drugs is definitely something that sets off him, according to these people that I've spoken to. And, we are obviously worried that he could have access to those types of things if he gets out. There's also one weapon that's not registered to Mr. White, but it's registered to his father that's in their home, and they do share that home. When I spoke to Mr. Black about the incident before he went to the hospital for treatment, he did admit that he had the mental break during these things, though he doesn't remember everything. It was clear that he remembered actually having the mental break and at least saying and getting into that mental state. So we're concerned about him getting access to alcohol if he's out and not staying on his treatment or staying on his medication.
Okay. All right. Now, Mr. Tolenda.
I do have some suggestions. If and I understand, I appreciate the detective's concern. If there's the concern that alcohol is a trigger for, let's just say that's the beginning of the downhill decline, perhaps an alcohol tether would be appropriate, because at least that way we would know where is consumption. Any consumption would be a violation, and it would also give us some comfort into his whereabouts. As far as the firearm in the home, Your Honor, I've had success in. I would offer the court. I would take custody of that firearm in my office, pursuant to a court order, and then have that firearm being held in my custody and control until a further order of the court establishing a release of that. And in light of any events that would prevent a return of that firearm, that would coordinate a sale with its registration. And I offer this, Your Honor, because it makes let's just say it takes the court and the police department out of the babysitting factor of it, and keeps the community concerns in a safe place.
All right, Mr. Talenda, I just have a few other questions for Detective Mata. Detective Mata, I see that he is on probation for 2200552OP. That case, if I'm, please correct me if I'm wrong, involved trespassing at a school in Oak Park. Is that correct?
Yes, Your Honor.
All right, and what was the nature of the case for which he's on? What was the nature of the trespass?
He was walking his dog during recess and was asked to leave. An argument occurred between Mr. Black and employees of the school. The next day, the employees of the school came to work and found that Mr. Black had left a voicemail. I don't know the exact contents of the voicemail, but he was pretty upset about the altercation, the verbal altercation that occurred the day before. And then the staff found feces and animal droppings all over the playground on the play equipment. And after reviewing the tape, after the police were called out, they reviewed the security footage and saw somebody there. They recognized him from the day before. Officers went out to Mr. Black's home on Oneida and made contact, and he admitted to being there. So he was officially trespassed from being on that school. But that's the broad strokes of that case, Your Honor.
All right, Mr. Talenda, I've reviewed the investigator's report in this case, and I am aware that the defendant is currently on probation for threatening behavior at a school in Oak Park. This case is a 20-year felony. It does bode well for the defendant, Mr. Talenda, that obviously you've been retained and he did turn himself in. However, I am concerned that he is a danger to himself and others. That this case involves threats to kill school children. It involves threats to kill himself. It involves threats to kill women. And I'm going to set the bond at $100,000 cash or surety. I am afraid that the defendant is a danger to himself and others. If he is released, he will have to be on a GPS tether for home confinement. He'll have to be on an alcohol tether. There'll be pretrial services supervision. He can leave home to test once a week for urinalysis. No computers, no cell phones, no electronic communication devices, no contact with any schools, no firearms, no dangerous weapons, no alcohol, no marijuana, no controlled substances. We'll see him back for his probable cause conference on March 26th at 11:10 a.m.
Your Honor, if I may, would the court
Yes,
consider
Mr.
10%? Could the court add a 10% provision on that just to make it realistic for the family to get to, let's just say, to have Mr. Black to be released under these terms and conditions in order to get him into or continue on with treatment? My concern is that while kudos to everything they offer in jail, I don't believe that the programs will be particular enough for Mr. Black, and I'd ask the court to just consider the 10% provision that would be more realistic, that would allow for either placement into another inpatient facility that is more in depth, or into outpatient counseling, or into a daily schedule of some type. I believe that if we can make that hurdle a little more attainable, I believe that the bond process in the pressure of the bond process during the pendency of the case will provide some benefit to the goal that I believe we're all looking for, regardless of the ultimate outcome.
Mr. Talenda, I guess given the fact that he's currently on probation to this court, and it also involves menacing behavior at a school, and given the threats that were made in this case while on probation for the other case, I'm not confident that the family really has any control over Mr. Black's behavior. And because I do find that he is a danger to himself and others, I am going to leave the bond at $100,000 cash or surety. But of course, you can bring it up again at his probable cause conference on March 26th if you have additional information.
Your Honor, would the court consider a release into a facility rather than rather than actually, let's say, make that a condition of the release? Could I ask for 10% and release into an inpatient facility or some more of a monitored setting?
Not at this time.
Okay.
All right. Have a great day.
Thank you so much. Mr. Black, we'll talk very soon. Mr. Black?
Yes.
You're gonna sit in jail for a little bit, and we'll talk very soon. I'll come visit you.
Thank you, sir.